Hi, this is Lee from the Law School Toolbox. Today, we're thrilled to have with us Dean Jackie Gardina of the Colleges of Law in Santa Barbara and Ventura. Dean Gardina is a visionary in legal education dedicated to making it more accessible and affordable through innovative teaching and learning models. She's also deeply involved in shaping the future of legal licensing in California. Dean Gardina, welcome to the show. Thanks for coming.
Thank you so much for inviting me. I'm excited to be here.
We're excited to have you because who doesn't like talking about the bar exam? Everyone loves it just as much as we do.
If you've already taken it and passed it, I think it's a great topic to discuss.
That's true. Fair point. Okay, before we dive in to all the things you have to chat with us about today, could you give us a brief overview kind of your path, kind of in your career path, how you got to where you are today, and then we'll dive into the bar exam.
Sure. So I probably, like a lot of your listeners, was told from a very young age that I should be an attorney, mostly because I like to say the opposite of whatever anyone else was saying. So I went to undergrad with the idea that I was going to go to law school, and I did take the LSAT, and I did apply to law school, but then started to have second thoughts about whether or not that's really what I wanted or whether I'd just been told that that's what I should do. So I hit pause and I got a job out of undergrad, and I ended up instead getting a master's in social work. And I did clinical outpatient therapy with kids and families for about 6 years. And during that time, I had an opportunity to be in the courtroom as an expert witness. And I also had the opportunity to help change some laws in the state where I was working, specifically laws affecting children and adult survivors of childhood sexual abuse. And both those experiences really reignited my interest in law school again. And I feel like that delay really helped me better understand who I was and why I wanted to go to law school. And so it worked well for me to hit pause and do it that way. So I ended up going to law school, and I remember in my personal statement writing about how I was going to use my MSW and my JD together. And then it turns out that's not at all the way my career went. So I always tell students, like, you need to be prepared for a class igniting your interest or an opportunity emerging you didn't even know existed. And you end up walking through a door and other doors open. And that's exactly what happened to me. So I was in law school, and I wasn't the top 10%. I didn't grade or write onto law review. My first year, I was still trying to figure things out. So I really didn't kind of grasp what I was supposed to be doing until my second year. And my grades reflected that. I was a middle of the pack person. So when it came time for career services to talk about potential clerkships, I wasn't in one of the invitation lists, but I was working with a professor as a research assistant. And she said, "Why don't you apply to a clerkship?" And I said, "Well, I'm not really clerkship material." And she said, "Well, if you don't apply, you won't get one. And if you apply, you might get one. So why don't you apply?" So I did. And I think in large part because of a letter that she wrote, which she never let me read, I was able to get an interview. And I clerked for Chief Judge William G. Young right out of law school, and then for the First Circuit Court of Appeals, Levin Campbell. Again, opportunities I never even knew about or understood when I went to law school. And then when I was clerking for Judge Young, he had a room full of 9-year-olds there to visit the court, and he was explaining what lawyers do. And he said, "Lawyers are teachers. That's what we do. We teach clients, we teach juries, we teach judges, we teach legislators." And I thought, wow, what a great way to practice law. So I started adjunct teaching in Boston while I was working at Choate Hall & Stewart, and then ended up applying for a full-time job at Vermont Law School, among other places, but ended up at Vermont Law School for about 15 years before I came out here.
Well, that is a meandering career path, which are my favorite types of career paths.
Yeah. And that's why I think it's always important for law students to know that whatever you think you want to do, it's likely that your path will have several twists and turns along the way.
So true. Well, today we are coming together to talk about the bar exam. And When we were getting together to meet about this podcast, you posed such a great question, which was, do you know the history of the bar exam, Lee? And then I realized my answer was kind of no, which is a little embarrassing considering what I do. So will you please educate me about the bar exam?
Yeah, well, I mean, obviously, the history of the bar exam isn't important to know when you're trying to prepare students for what currently exists. But I
True.
think
Thanks for giving me that little bit of a bonus right there. That was very kind.
absolutely. Um, But I think understanding the history is also helping to understand what kind of changes are being discussed at the state level now. And I think part of what's driving these conversations was COVID in part, is the disparities in bar exam performance across socioeconomic status, age, race, ethnicity, et cetera. And a real question of whether or not it's the most effective way to actually figure out who's competent to practice law. So if you look back at how we have licensed attorneys since since the Constitutional Convention or even before that, you'll find that it was done in a lot of very diverse ways, and not with any kind of rigor or necessarily substantive knowledge. When you look back early on, people simply read for the law, worked in a law office, and then local courts and attorneys would interview them. So it was called an oral bar exam, but it was much more of an interview, like 5 to 10 minutes, much more based on who you knew and how to get access to the court and the bar than necessarily what you knew. And that was the case for, I'd say, most of the 16th century and into the 17th century. And then in the 18th century, things started to change. And I don't think that you can untie the bar exam from legal education because as we know in the United States right now, you don't become eligible to sit for the bar in the majority of states. In fact, many of them, except maybe California, Vermont, Tennessee, Massachusetts, where there are state accredited schools, unless you graduate from an ABA accredited law school. So where did that come from? Why did we go from reading for the law, as you can still do in a couple of states where you just studied and worked in a law office, to requiring people to not just have an undergrad degree, but actually have a graduate degree as well before they're even eligible to sit for the bar? So I think it's really difficult to talk about licensing and the bar exam without talking about legal education. So I don't know how far you want me to go down that rabbit hole, but the current test didn't really have its iteration until the 1970s. So there was no MBE until the 1970s. There were written exams. They're often done at the local level, written and graded locally, not just even at the state level, but sometimes court by court or jurisdiction by jurisdiction. And it wasn't until really the 1920s or 30s that they started to formalize both the educational pathways, and the NCBE was created to try to standardize testing across the United States. But all this gets tied up with also creating the profession that's exclusive. If you look back at the history of the bar exam, at no point was it identified that a particular pathway to licensure was necessarily better for the public, but rather it was better for excluding people that were considered to be undesirable. How do you make it more challenging for people to actually enter the legal profession? You require them to have an undergraduate degree and a graduate degree. That's obviously going to limit dramatically who's going to be able to follow that pathway. And that's true for a number of steps that were taken in the licensing decisions that were made, where at times when the legal profession was starting to grow and become very diverse, and then the licensing pathways were narrowed and made more difficult to traverse. And so it's hard to kind of untangle it from kind of the Jim Crow era in the 20s and 30s, and the segregation of higher education at that time. Black and Indigenous people weren't getting access to undergrad and graduate school, and so they couldn't ever have access to the legal profession. And so it has a very, I think, challenged history when we think about why we put these licensing pieces in place. And it's important for people to step back and ask the question, what's licensing supposed to achieve? Well, it's supposed to tell us who has minimum competence to practice law to protect the public. And is the bar exam, as it currently consists, is that the best and or only way to achieve that?
Yeah, that's a lot of stuff I didn't know. That's so fascinating. And it makes so much sense when you really sit with it about all these gateways to the profession and how, these stumbling blocks in dressed up as this idea of protecting the public end up just being an exclusionary, arm of the profession.
Yeah, and I think that there is the idea about standardized tests was when psychometrics came around and people became really invested in it, is this is going to be a fair way to do it. But there's an underbelly to it that's also about exclusion. I mean, the SAT and the LSAT were created around the same time in the 1940s, late 40s and 50s, when they were really starting to think about how can we better tell who has merit. And as we know, standardized tests have a very, I think, difficult history when it comes to cultural differences, race and ethnic differences, socioeconomic status, and all of that. So it's hard to entangle it from all of
Mm-hmm.
that.
Okay, that's a lot. So the bar exam is really loaded. It's got
It
kind of
is.
a challenging history. And now we're here in the present day where there's been a
Mm-hmm.
lot of discussion about the effectiveness of the bar exam in assessing lawyer competency, which is what you said, was the goal, right? That was, or the stated goal, whether
Stated
there's
goal.
an
Right.
underbelly goal, but the stated goal. So in today's current debate that's happening, do you think it's effective?
Well, I'll give you two things based on my experience in California specifically, but I think it's true in other states as well. 2015, the executive director of the State Bar of California was invited to a hearing at the Assembly Judiciary Committee, California. She was asked a very specific question. How did the state of California choose 1440 as the cut score, the passing score in California? She didn't know. They had been asked that question beforehand, and they went back through all of their records. They had absolutely no basis for choosing 1440.
This is not a
So,
surprise to me. This story does not
no,
surprise me, especially because
yeah,
we're going to get to what California is doing right now. But this doesn't surprise me. My bar
right.
dollars at work. Okay, here we go. Keep going.
So there should have been what's called a standard setting study that kind of figures out what's the right passing score, because it seems somewhat odd that you can be competent to practice practice law in New York at a 1330 or a median 1350 across the entire country, but 1390 or 1440 you need to be competent in California. So what's the basis for that? So already you're questioning, okay, so what's the effectiveness of 1440? So the other thing that came up is obviously what we're trying to test is kind of what a new attorney needs to know, understand, and value to be effective and to protect the public. No one had done a practice analysis study ever to ask the question, well, what does a new attorney need to know, do, and understand? And are we testing the right things? Because if we're not testing the right things, then we're not actually setting minimum competence for new attorneys, because we don't actually know what they need to know, do, and value. So California went about, and that was the California Attorney Practice Analysis Working Group. And also the NCBE partnered with California to do a national job studies so that we'd actually have the information of, are we testing the right subjects? Are we identifying the right skills, et cetera? So there was both those things, to me, raise questions of, no one really asked the question of, are we testing the right thing? And are we setting the right passing score? So off the bat, I'm already skeptical.
Yeah, that story is just really special. The fact that we just all, I am a child of the 1440 era.
Yep.
I did pass my bar on the first time, but you put so much weight in these numbers because they are held up as, this is what it means to be a lawyer here in California. And now I was just having a talk with a bar applicant about kind of forum shopping for the right bar around the country, because you can be less competent in one jurisdiction than in another, which is also a little hard to balance when you start really thinking about it.
Yeah. Well, and even that you defined it as less competent rather than
A
just
fair point.
there's no evidence that that person is less competent
It's
at
very
all.
true. That's so true, because I know amazing lawyers who have multiple bar exam failures on their resume. So I
Yeah.
know from personal experience, we've all read all of the stories, but we know, all of us know, wonderful, brilliant lawyers who have struggled with this test, or who have not been able to practice because they were not able to kind of move past this test.
Yeah, and that's why I think it's important to ask the question, is it the right mechanism to determine who's going to be a skilled, competent, and ethical attorney? Or is there a better, different mechanism that's more inclusive? I mean, even for people with disabilities, the challenges that they have in getting accommodations at the bar exam level makes it really difficult for them to be successful at that stage. Is there a more inclusive way for them to establish competence than needing to sit for a 2-day time standardized exam?
Yeah. And those accommodations can be expensive and time consuming and require appeals and all sorts of stuff. So this all makes me think about how in COVID days, they just changed the passing score. And all of a sudden it was 1390. And now you could pass with this new score. But then this was all under the idea of it being a bit more inclusive. That's what I remember reading, or, creating less barriers to entry in the profession. Yet the pass rates didn't really change.
No, and so 1390 actually had evidence to support it. So that came out of the standard setting study that the state bar did finally do after they were called out by the assembly for not knowing why they chose 1440.
I'm glad they have an
But
answer to that question now. That makes me feel better.
but I think what's interesting is California bar applicants will do better than the national average on the MBE. Even my school will, meet or exceed the MBE. And the MBE is used for scaling the written portion so that there's validity to it. So it's always hard for me to understand why we could do so well on the MBE as a state and yet have a pass rate that is so dramatically lower than other states using the exact same MBE questions that do more poorly.
Well, I mean, then thank goodness they're just throwing that MBE out the window so we can just start with a whole new crop of data. I mean, this is just makes it more fun and
Mhm.
terrifying for those whose, futures are all wrapped up in this.
Yeah.
Yeah. Okay. So there's a lot here. Like, where do we even go? So there are some open questions, about whether or not this is an effective way to determine minimum competency. It sounds like people have been asking this question, that they did these kind of national studies, and some new stuff has bubbled up out of that. I think the NextGen bar exam is probably what most people have heard of. So what do you think is coming in the future of the bar exam? We know the NextGen is coming because they're going to stop giving the MBE at some point. So everyone's going to need to adopt it. So it's coming down the pipe in the next few years. But what's different about these tests, and how is it a reaction to what was being discussed in all of these studies?
Yeah. So first, not every state has
I know they're dribbling
said,
it out,
said that they're going to adopt the next gen.
but I
So I
love
think they,
getting those little, because I'm a license. I mean, I have licenses from the NCB, so I get the little like flash, breaking news, Wisconsin. I'm
yeah,
not sure if Wisconsin has signed on, but everybody's, it's like every few weeks I just get a big, big email. Very
right.
exciting.
Yeah. Um, so right now, California's not, and that's a pretty
Right.
big loss for the NCBE because of the amount of takers that are in California. Nevada hasn't.
Mhm.
They're developing their own kind of exam plus supervised pathway, with the exam portion being able to be completed in law school.
And didn't I
Um,
just see something that they're thinking of licensing the Kaplan questions from California?
Potentially.
Yes, interesting.
Yeah.
Okay, well, hope they're good
So-
questions. We wouldn't know. We haven't seen them, but I
Nope.
hope they're good.
And they have plenty of time to create them, test them, and validate them. So I think we'll be fine by February 2025.
Totally. It's October 15th, everyone, that we are recording this, and they have not yet, I think, finished drafting the questions.
Well, the Supreme Court has not yet approved the contract after it went back down to the Committee of Bar Examiners to get approved and then back up to the Supreme Court. They haven't issued a final decision. I'm assuming they will. But one of the things we asked the State Bar when they were first considering this is, okay, what happens if it turns out they can't create 300 valid, reliable, and fair test questions in less than 6 months? Will you be able to pivot back to the NCBE and get the MBE? They didn't have a backup plan. Like it was Kaplan or nothing.
I know there's no backup plan because they're going to use these testing centers and they will not allow the multiple choice questions from the NCBE to be given in this format. Yeah. And they've got these experiments. We'll link to some of our other podcasts on that. So they have to have questions for that. And then they have to have these other questions. And if nobody listening has ever tried to write a multiple choice question, they're really hard. They're really hard to write. They're really hard to write. It's
and
really, really hard.
That's why the NCBE does test questions in every bar exam because they're testing about 25 questions to check it for that fairness, reliability, validity, and all of that. And Kaplan's not going to have any ability to test that. We're not even necessarily going to know the scaling or anything until after the exam is completed because they have to do all that afterwards.
In real time, which is just what you want to hear when it comes to something like this.
I feel so worried for your listeners that are like, I was going to sit for the February 2025 bar exam.
Yeah. I know. We're talking about this. I talk to students about this, all the time. And I mean, it's rough. I'm still telling folks if they want to sit, they should sit. I'm sure that you're giving guidance at your school too. This is, it is all about time and, waiting till July. We also don't have a great idea what July will look like either. And so, I do believe that you have to play the hand that you're dealt. And unfortunately, you're getting dealt this hand just as students who took that, October 2020 exam were dealt, kind of a bit of a wild hand too.
Yeah, I think that's a good point. And I think what is really telling about the State Bar's decision to move on this so quickly, they really tout that their primary mission is protecting the public. And we say that the bar exam is supposed to protect the public. But this decision was made entirely based on budgetary concerns.
I was like, I feel like all they complain about is how broke they are. And then they raised our bar fees.
Yeah.
So, yeah, I think I got that notice while I was recording some of these podcasts about the choices the bar were making. And it's not making it easier for me to pay my bar fees. I mean, I will, because what choice do I have if I want to keep my license up and running? But yeah, you're kind of like, okay.
Yeah.
If you enjoyed this video, please take a second to give us a like and leave a comment. And be sure to subscribe to our channel so you don't miss any future content. If you have any questions, feel free to reach out to us via the contact form at lawschooltoolbox.com.